Item 4, I'm for the commission.
Milad, this matter milad, relates to notification by which milad, supernumerary post was created. Milad. Now, milad, this similar notification is subject matter of challenge is another writ petition. Milad. Now, that writ petition was adjourned since milad, the Supreme Court is in session of the matter. Milad. Now, the court has recorded in its order milad, and adjourned the matter. Milad. Possibly, milad, because milad, our case is that illegal recruitment was made in which manner CBI is investigating. Now, this post was created to accommodate waitlisted candidate, whereas we are seeking recasting of the panel.
Physical education, work education.
Yes, yes.
But yesterday I have passed an order dismissing the writ petition, granting leave to the petitioner to take steps in accordance with law in future if situations were arise. Because today everything is academic.
No.
Unless and until the notification which was issued by the state respondents creating supernumerary posts is saved by the order of the Honorable Supreme Court and the order passed which is to be passed by the coordinate bench where the issue is stayed. So your right being a teacher seeking appointment as assistant teacher, being a candidate seeking appointment as assistant teacher in work education, physical education group from wait list cannot be delved into. It is now only an effort to keep this writ petition alive when the very basis of this writ petition is in difficulty, is unsettled. So therefore let the validity and legality of the notification creating supernumerary post be decided by the Honorable Supreme Court.
No, Supreme Court is not deciding the validity of the notification. Supreme Court is deciding the issue whether it is to be done by the CBI or not, the investigation part. Now, if ultimately after investigation something comes out, that has some connection with this notification. That's why Supreme Court has made this observation. And
but before the coordinate before this bench, before the coordinate bench also, there is stay of operation of the order.
Stay of appointing direction.
No, that notification has been stayed.
No.
The
appointment has been stayed.
Not to issue the appointment letters because recommendation is complete.
This is the order.
Reason is because this
we were
notification.
We were there in that matter also.
Creation of supernumerary posts now is in unsettled position.
If ultimately our petition fails,
you are not a selected candidate. Are you a waitlisted candidate?
No. It may not be.
What you have prayed for in the writ petition?
Cancellation of this notification.
How can he pray for cancellation of a notification which does not concern him?
And prayer C.
Now, if the notification is not saved in another batch of writ petitions which is pending before this court, then this writ petition will be allowed because he has prayed for cancellation of the notification.
Yes, but we are on.
Or when those matters will be heard, this matter can be.
Our response to this mainly the state, because the state is
the only remedy I have.
But
because otherwise
the thing is the notification
matter. There was no challenge.
The notification which does not concern the petitioners. How can they file a writ application for cancellation of such a notification? I'm unsuccessful. Panel expired in 2019. Now in 2022, government wants to accommodate waitlisted candidates. Unsuccessful candidates from the panel.
But in those matters also similar prayer has been made.
Yes.
And similar submission was made.
All unsuccessful candidates have come up. So naturally, because
the same matter, when other matters are pending, why this matter will be dismissed today?
Yes. But only one thing, may I?
That is matter, Dr. Patro, this notification was not under challenge.
It was annexed, I think, but it was not placed. Just kindly see the notification once.
No, at this stage, this is not required because I cannot decide the issue without entering into the issue, merit of the matter.
No, not for deciding. I'm just requesting the court to look at it to get a better picture of why this because multiple cases will be coming up. Even new cases are being filed. Even now by the successful candidates there, they have filed certain matters. One was withdrawn to file afresh.
Now, I am posing a query to both of you that if whether at this stage this notification dated 19th May 2022 by which supernumerary posts were created can be decided without any order being passed by the Supreme Court.
Can you see this order, Millet?
কোনটা দিলি ওই সব আপনি আছেন না আমি ছাতে আপনি সব মুখস্থ করে ঘুরে বেড়াচ্ছি
এখানে অ্যাডজার্ন করলো ইন ভিউ অফ অবজারভেশন অফ সুপ্রিম
ও আচ্ছা
If the situation has not been altered, why up to 9th of August 2024 it has been adjourned?
Because the matter is pending with the Supreme Court.
Whether any date is fixed before the Supreme Court?
That I must have, but I have to ascertain the date. And this matter is part hard. That's the whole difficulty.
Which matter?
All these bunch of matters.
Before Justice Basu.
No, part hard day, but assigned.
No, part hard.
Part hard করেছিল রিলিজ করলো না একবার
না part hard, hard in part.
The same order be passed. See the order.
No, I know the order. What I cannot say before the court is that the courts have been confused into passing these orders. Courts are totally confused. That is why I wanted my lord to see page 19.
Because of multiplicity of...
Yesterday, I spent the entire evening reading 300 pages of the division bench judgment because I told my lord that I would come back and apprise and...
Whether any observation is made.
Yes, and the total judgment is a result of confusion created by the litigants.
They shouldn't say this because they have tested the order after Supreme Court.
No, it is going up. The confusion is going all through. Because let me be more clear. We had also approached the court for leave to file to create supernumerary posts. We meaning the School Service Commission. That never went to the cabinet. That was immediately thrown out by the court that how can you propose such a thing? We wanted to withdraw. That was not allowed. And the court said, how could you propose that you want to create supernumerary posts for illegally appointed candidates? Giving certain logic that they were working for so many years, they are now dependent. There's no complaint against them. We were thrown out of court. But that never went to the cabinet. That has nothing to do with the government. But this notification, this is where the government tried to create supernumerary posts for the victims, not for the illegal appointees. Somebody has to read this notification in details. And work education, physical education has been segregated from the other 4 categories. That is what I wanted to show. If the reason for creating the supernumerary post is mentioned in the notification, in both but what has been told to the courts, that see, this is what the School Service Commission wanted. See, this is what was in the cabinet. In between, this was there, and the cabinet was for this notification, not for which was a totally opposite purpose. We wanted to create supernumerary posts for the illegally appointed candidates, if I may use the term illegally, because they had been teaching for 3 to 4 years. There was no complaint against them. They had the eligibility.
But what right they have got?
They do not have. That is why we were thrown out of court.
For which?
That is why we also wanted to withdraw.
Their interest is required to be protected by creation of supernumerary posts.
Yes, that is why we wanted to withdraw.
Why the government is leaning upon those illegally appointed candidates?
The commission. It was the commission who had filed this. The commission came up with this proposal. And that is why later on we wanted to withdraw. The court did not allow us to withdraw. The court went to it and
No sympathy should be shown
No,
to those
exactly.
candidates who have been appointed illegally.
Yes, but this notification is not for them. This notification is for the victims of these illegal appointments.
Yes, but by accommodating the victims in a roundabout way, you are accommodating the illegally selected candidates.
No. They have been removed.
No.
They are
Send,
being
send
removed.
those throw these illegally selected candidates to garbage and appoint the candidates who could have been appointed.
Yes, that is absolutely correct, and that is what is being done. These supernumerary posts is not for accommodating them. They will be thrown out. But since 2016 till now,
Dr. Patro, you have to consider what is the purpose of creation of this supernumerary posts.
Yes. So
indirect object is to accommodate illegally selected candidates.
Especially not in case of work physical. Kindly see work physical. There is no illegal appointees in work physical.
That can be segregated.
That is,
if it is possible.
Yes, it is in the
notification. They could not segregate to the Supreme Court, despite direction.
No, not that segregation. Again, you are confusing. That segregation is between illegal and legal. My lord is talking about segregation of work education from 9, 10, 11, 12. Don't take a word and immediately use it in a common way. Kindly see what is mentioned. Kindly see the notification once. Page 19. Kindly see how it's been dealt with. The object cannot be to just cut down all the trees. You want to weed out the weeds, no problem. Page 19, if my lord sees, clause A. It is divided into two parts, Roman 1, Roman 2. Roman 1 deals with all those selection processes which got scrapped. 9, 10, 11, 12, Group C, Group D.
And
Roman
B deals with B deals with
not B. Kindly see there's a Roman 2. After A, Roman 1, Roman 2.
Yes.
Roman 2 is the matter which is before the court. Roman 2 is a matter which has never been argued anywhere except in these cases. But everything is being tangled together. For absorbing all waitlisted candidates. It's got nothing to do with any illegal appointees. And kindly see the reason given in Roman 1. Adversely affected due to recommendation made by jumping of ranks, etc. Two totally different categories of supernumerary posts.
But Mr. Ahmed, with regard to appointment of waitlisted candidates for in the posts of assistant teachers in work education, physical education, there should not be any difficulty. So far, the creation of supernumerary post of 5261 to accommodate illegally appointed candidates issue is completely different. But at the end of the day, the selection process which was initiated for filling up the post of assistant teachers in work education and physical education there is no issue today. That selection process has been
That
saved,
submission is being
and
made by
it has
Mr.
passed
from the bar.
It has qualified the test of
Let them explain that what they have said in their notification. What is rank jumping? Why they are aggrieved?
no,
Why
but,
this
but,
word victim is being
but
used by the
after
commission?
coming to this determination, I have found that appointment or selection process of upper primary work education, physical education, SLST 2016, that has not been interdicted by the court at any stage.
Blood, there are issues, blood.
It has
Blood, this cannot be
qualified the test of judicial review. So therefore, if upon creation of supernumerary posts,
but they cannot do it.
This 1600 candidates can be appointed.
How can they, blood? In my career, blood, I have never heard of that during after selection process, this notification can be issued to accommodate something saying that these people are victim.
No, that's legal argument. Now,
with regard to upper primary physical education, work education, you are also not saying that any victims are there. But that is in connection with.
In fact, I have pleaded that there was malpractice.
If there was malpractice, then
and Supreme Court is not insisting of the matter. The investigation is going on.
No, not work education, physical education. Again,
this
is not between
the Supreme Court.
This is not
you have to be very specific before the court. That where is the difficulty?
But I tell you, Lordship,
appointment to 1600 candidates when the selection process of upper primary physical education, work education has passed the test of judicial scrutiny.
That there is pending cases, and the investigation is not confined to a certain area. It is open. Not Mr. Bhatru is not by raising his voice, but trying to confuse.
I just cleared the confusion, not made the confusion.
The commission, he must be independent.
Why you are getting boisterous?
I don't.
In addressing this.
I don't want to.
Why?
That's my.
You are looking so disturbed?
That is my
point.
When
the court is asking a query to you,
I am not at all disturbed. All that I am.
You have to answer the query of the court.
Most certainly.
To satisfy the court.
All that I am saying, that. By raising voice,
instead of expressing your aghast,
with this period of time, doing all this matter, we are not only we, the people are.
But the court will go on changing, and you have to satisfy the court.
Most certainly, that I agree. Then that I agree, that I agree. Court is now taking up new matters, most certainly, I have to satisfy your Lordship. I have to.
And law is not a static subject; it's an ever-changing subject.
I'm not on law, these are facts. Now it has become
no. So far 9, 10, 11, 12. The selection process is bad. There are illegally selected candidates. For them, try to apply your mind. For them, this creation of supernumerary posts. But so far, physical education and work education teachers, the basic selection procedure has qualified or has been tested before this court, and it has been upheld by this court that this is correct. If this is correct, and for waitlisted candidates, supernumerary posts are created to accommodate them, where is the difficulty?
First of all, apart from all that I have submitted before your Lordship, that the
very well, this is not a time to consider this issue in this matter.
I only wanted to put it in the mind of the court, the distinction between that subclause 1 and 2.
No, subject to hearing the petitioners also, this can be segregated.
Yes.
Provided there is no restraint ordered by any court.
Yes, that is the difficulty. The coordinate bench has given the stay. That is the real hurdle. Or else the...
Issue. In the writ petition, notification dated 19th May 2022, creating supernumerary posts.
Only one thing should I let this order possibly may help you, Rashim lad.
Just a minute. Creating supernumerary posts for appointment of candidates from waitlisted appointment of candidates from waitlist prepared in connection with first SLST 2016 upper primary for appointment of assistant teachers in work education and physical education group is under challenge. Stop. It has been jointly submitted by the learned advocates representing the petitioner and petitioners and the West Bengal Central School Service Commission that this notification dated 19th May 2022, the entire notification dated 19th May 2022, issued by the Deputy Secretary to the Government of West Bengal, creating supernumerary posts, has been stayed by a coordinate bench on a batch of writ petitions. Stop. Next paragraph. In view of the order passed by the coordinate bench on a similar issue, at present the writ petition cannot be delved into.
The notification has not been stayed. The issuance of appointment letters has been stayed.
Now, service commission that appointment on the supernumerary posts created via notification dated 19th May 2022 has been stayed by the coordinate bench. By the coordinate bench. Stop. Or by a coordinate bench in connection with the batch of writ petitions. Stop. Since identical issue is involved in this writ petition, wherein challenge has been thrown to this notification dated 19th May 2022. At this stage, the issue involved in this writ petition cannot be delved into. Stop. Next paragraph. Let the matter go out of list with liberty to mention.
But what I'm trying to write story that this issue of segregation was brought to the notice of the coordinate bench, and this order was passed.
Very well. This is not the right time to consider this. Since I am not in a position to hear out the matter, other matters have to be touched.
I'm sorry.
So keep your energy.
Any of my expression that
yes
should not matter.
It is সঙ্গে রাখো ওই অর্ডারটাও রাখো yes give that order. No use of hearing both of you because since there is an order restraining the authorities from giving.
And the main answering respondent will be the state. Learned Advocate General was appearing because this creation is the state.
No, I have heard you. I'm hearing you, both of you, since other matters are also coming.
Yes, that is why I wanted to point out, or else there was no need.
There is a necessity to understand what is this present situation.
Okay.
Because I was not in this determination for quite some time. Yes.